everyone, and welcome to our session this morning. Next slide, Chris. So, welcome to our session, Protecting My Business, What Should I Prioritise? We're going to be talking about three key areas this morning. And I guess we acknowledge that not all businesses have endless funds to spend on legal services. So we've tried to really focus on three areas that that you need to focus on for your business. Chris, I think you might need to go on mute. I think there's a bit of sound.
No problem.
So the three key areas being intellectual property. Obviously, as creative businesses, you're all going to be generating ideas, innovations, intellectual property. So we're going to talk through a little bit around how to protect your brand and your broader intellectual property. Secondly, data protection. I think most businesses now, are processing usually vast amounts of data, even if you don't realize it, whether that's data of your partners, clients, employees, or end user data. So we're going to talk about some of the key areas to focus on when looking at data protection. And lastly, e-commerce. And the reason we've chosen this to focus on is just because there's a whole raft of legislation which governs e-commerce, so trading online, dealing with consumers, trading at a distance. So we're going to take you through some of the key points to remember or to be aware of when dealing with consumers online. So I'm going to hand over now to Chris, who's going to take you through intellectual property.
Thanks, Susie. Thanks for coming, everyone. I'm mostly going to be talking about the branding side of things today. In part, I was inspired by a couple of conversations I had with friends running businesses in Bath who'd run into some problems in relation to the naming of their companies. But a lot of the things that I'm going to talk about stretch to other things as well. So the naming of your products, logo design, that sort of thing. All of the principles that I'm going to talk about apply to that. And if there's time, I'll try and finish off with some more general IP contractual points. So starting with the branding side of things, when you're coming up with a company name or a product name of some sort or a logo for your business, that kind of thing, generally, if clients come to us with that process, we'll advise them to look into two separate things. One is making sure that you can actually use that name or logo, and the other is having a think about whether it might be useful to register it or not. There are common themes in both of these things, as you'll see from this slide. Thinking ahead is the main thing, really. All of the activities that you'll take under our advice, hopefully, will involve you deciding what you're going to use the name for, where you're going to use it as well. And generally, you're trying to look maybe 3 years ahead, something like that, 3 to 5 years ahead, ideally. But if that's too much, then, you're really trying to go through these processes as early as possible to avoid any unwanted hiccups. Let's start with the clearance process. And as I said, this is really just making sure that what you're planning to use is usable. There's a bit of a caveat at this stage because registration does feature a little bit at this point. If you do decide to register there, it's important you come up with a brand name, for example, that isn't descriptive or non-distinctive. And what that means is, if you're selling peanuts, you don't call your brand, Real Good Peanuts, for example, because that's going to be very, very difficult to register as a trademark. One, it describes what you're selling, and two, the real good part or things that praise your business or products generally are seen to not be distinctive by most English-speaking intellectual property offices. I'll come back to that point, but really what we're talking about when we're talking about clearance is what is already out there on the market with a similar name or logo type to what I want to use. And being already out there on the market can mean you've got a registered brand, a registered trademark can also mean that you've used, in the UK at least, used in the course of your business a name or a logo that has generated some sort of goodwill. You'll probably heard people talking about passing up before, and that's what this is. Goodwill's a pretty low bar, so even if you've got a small amount of trade, you may have generated some local goodwill. So it's important that when you're seeing what's already out there, you're not just checking registries, you're also checking social media, search engines, similar trade websites, that kind of thing, just to get a good idea of who's already using what. Obviously, when it's an identical mark to the one you want to use for identical stuff. Real good peanuts for peanuts. Obviously, bearing in mind you can't use Real Good Peanuts to be a terrible brand as a registrable one, but if it's double identity, as we refer to it, then obviously that is a no-no. But often businesses struggle with similarity questions. So what if the mark is different by one letter? What if the earlier mark is different by two letters? And what if it's not peanuts, but it's selling peanuts? It's not peanuts, but it's hot dogs, that kind of thing. At this point, really, I think the important thing for us to say is it's better to be overcautious when it comes to this. A lot of businesses tend towards thinking, oh, well, peanuts and pints, totally different words. It doesn't matter that the services are the same. No one would ever get confused. I'm just going to use it anyway. Well, that is unfortunately how a lot of branding comes unstuck at a very early stage. It's a legal question. Both of these points are legal questions. So there are set tests for similarities. Generally, what courts and tribunals are looking at are they visually similar? Are they conceptually similar? Do they sound the same? And you're looking at it from the perspective of the person that is buying the products or services in question. So, it's at least a 3-stage test in terms of trademark similarity. And then when it comes to goods and services, it's a much more than 3-stage test. So you're looking at, can the goods be substituted for each other? Are they part of the same supply chain? Would you find them in the same places as a consumer? All sorts of various different things. So essentially, these are the kind of questions that you may have to ask yourself, but they're the kind of questions you want to be fairly certain of, unless you're taking legal advice, because the tendency is to think it's not a problem when it often is. Last point on clearance. There are ways of preventing use or registration that are based on reputation. So if I'm McDonald's and someone produces McDonald's tractors with a similar sort of yellow M, even though I'm not a tractor manufacturer, because I can show that I am so totally famous in the UK, I'd possibly be in with a shout at preventing you from using that mark, purely on the basis that consumers will see my signs and think it's me, even if it's for dissimilar goods or services. So yeah, I think the bottom line for clearance is, be careful, be very careful. And if you are in doubt, then there are plenty of good legal advisors in Bath and Bristol who will be able to help you with stickier questions. Just to illustrate how difficult it can be to figure out similarity, dissimilarity. These are two opposition decisions made in the UK. I don't know if you can see my cursor or not, actually, but first one, the application mark, so someone wants to trade under Nodo Pizza Co., was opposed when they tried to register it by someone that owned the brand Lodo, and beneath it you've got an application for YOLO in a square that was opposed by someone who already owned Yobo. Both of these decisions, despite on the face of it looking pretty similar, two logo marks with words that sound similar-ish, and to word marks produce different results. They're both the same products as well. So, you know, Lodo was for food and Yobo is for clothing. You know, perhaps not, there have been sticky decisions, but I think the point I'm trying to make is that you can't guarantee that your mark's going to be dissimilar, even if you turn it into a logo that looks pretty different. There are still risks involved, and it can be difficult to figure out which earlier rights are going to get in the way of your use or registration. Now, these are opposition decisions, so that means someone is saying, no, I don't want you to register this brand, this mark at the UK IPO, but it also works for infringement proceedings, which is where someone is with early rights is saying, no, I don't want you to use that brand or mark. And in saying, I don't want you to use that brand or mark, what they're also saying is, I potentially want to sue you for the money you have made or the damage you have caused whilst using that mark. And that's really where the main danger comes in. And that's really why you're clearing for starters. It's not just that you want to register the brand potentially, it's that you don't want someone to sue you for infringement or for passing off. So registration, is the next bit. The reason people register trademarks is because, as I mentioned earlier, goodwill can be local, for instance. You have to prove goodwill. So if you're going after someone for passing off, you have to show that you have built up goodwill so that you can stop someone from using a similar mark or brand. Registration cuts a lot of that out. So, you spend your money at the UK IPO or the EU IPO or WIPO or wherever, in whichever territory you're operating in, and you get a registered right that is, because it's on a register, it's essentially taken as you have some rights in it, and they're not local rights, they're national rights. So there's no proving goodwill, nothing like that, at least at the start. It's much easier to enforce. If you're going to send a cease and desist letter to someone, you can simply say, have a look at my registration. It's the same as your mark and it's for the same goods and services. Please stop, which is much easier than have a look at this mark. I've got goodwill in it as proven by the 58,000 pages of annexes that I've put to the letter. So registration generally a pretty good idea, and it's a good idea to get in there early as well. Also, anyone undertaking a clearance search will probably come across your mark and it might deter them from registering. As ever with these presentations, there's a Brexit alert. We are leaving the European Union, which means we are leaving the EU IPO as well. So if you apply for a trademark in the EU today, unlikely that it's going to be granted before the 1st of January, which means that you won't automatically get a UK trademark, which means that you will have, from the 1st of January, if you've applied for an EU trademark, 9 months to apply for a UK trademark and backdate it. But you are going to have to pay for the UK and the EU. There are other supranational registries. So the UK, obviously, a national registry. EU is made up of all of the member states' registries, but there's an EU overarching register. So if you apply for an EU trademark, that covers all of the EU member states. And then there's an international system, which means you can take a national or an EU trademark and then spit out various other national trademarks from that application and make it easier to renew. So I think the take home here is really what I said at the start, just plan ahead and get in there early. We have talked about some of the things that are registrable and not registrable earlier in the slide, but just to remind you, if you're coming up with a brand name that describes what you're doing, or if you're coming up with a brand name that's not very distinctive, just calling yourself Really Great in the case of Really Great Accounting, then it's pretty likely your trademark's going to be refused unless you show that you've traded for ages and people associate it with you. There are offensive or trademarks that are against public policy. So, any number of things. Very famously, tiny penis clothing was refused. Usually offensive religious slogans are refused, that sort of thing. And yeah, domain names and company names I want to touch on very briefly, but a lot of people say, I've registered the company name, therefore I can stop people using my trading name. That's not the test, and it's not strictly true. You can sometimes stop other people from registering other company names, but what you're talking about really is either registered trademark rights or, in the UK at least, goodwill. Registering a company name doesn't necessarily give you goodwill, and it's not a registered trademark right. Domain names, equally, they operate in a separate sphere. It all depends on registered or unregistered trademark use. So that's very much worth bearing in mind. We'll share these slides, but these are some useful links for you. So lots of registration type information at the UK IPO, the EU IPO, and WIPO. And TMView is generally a good place to start with clearance. It covers a number of different territories. So if your 3 to 5 year plan involves, trade in the US, trade in Australia, you'll want to clear in those places. You'll want to check out the state of play there. TMView can help you do that. There are other things to look through as well. If you're talking about logos, then there's Design View, sort of the same URL, same word. You can type it into Google. But yeah, I'd say that these links are the ones to get a start with anyway. Just very quickly, as I wasn't sure I'd have time for this, but as startup businesses, you'll be dealing with a lot of contractors potentially, and a lot of people who won't be employees, generating content for your websites, generating marketing material, generating software programming, generating logos, all sorts of things like this. Under copyright law and under most IP law, unless someone is an employee, they are going to be the first owner of all of that stuff. So it's very, very important that you decide early on who is going to own the IP in all of this stuff. And generally speaking, the position should be that it's your company. It's going to be much easier to keep records. It's going to be much easier to monetize it. It's going to be much easier to show value on the books for it. So the way you do that is by making sure that in all of your contracts, intellectual property rights like copyright are assigned to the company in writing. They can only technically be assigned in writing. If someone has already done something and they haven't assigned it to you, you can retrospectively assign it to you. So you can go back to them and ask them to sign an agreement that assigns the copyright for the stuff they have already done to you. If you're not confident with that, then obviously we and other IP lawyers can help. Last point, confidential information. This is probably the most common thing that early stage businesses have to think about. And it's exactly what you expect me to say here. Put together some NDAs, make sure that they specify generally what you're going to talk about. Obviously, don't disclose the detail of what you're going to talk about in your NDA before it's been signed. And make sure that non-disclosure agreements, confidentiality agreements are signed before you start talking about your detailed and excellent plans for taking over the world. And with that, I am done. So thanks very much.
Thank you, Chris. Good morning, I'm Hannah and I'm a solicitor in our commercial and data protection team. Chris is going to be controlling the slides, so if you see me doing sort of a crazy thumbs up, that's why. So I'm going to focus on some of the key areas to prioritise when thinking about data protection for early stage businesses. And I want to address this by looking at 3 key areas. The first being keeping your data secure. The second being making sure that you're transparent about your processing of personal data. And then thirdly, looking a bit further at the accountability principle. So really this is about your internal record keeping and how you're demonstrating compliance with the data protection legislation. What I'll do is I'll take each of these in turn, but a common theme that runs throughout is the importance of getting it right, because if you do that, it enables you to build consumer confidence, because your consumers and your customers are assured that their data is in safe hands. And it's also really important to get into these good habits at the outset, because it means that you've then got the infrastructure in place as the business scales. Next slide, please, Chris. So what steps should you be taking to keep your data secure? It's fairly self-explanatory that in order to keep your data secure, it's fairly self-explanatory that in order to build consumer confidence and to demonstrate your compliance with data protection law, you need security measures in place. But you're probably wondering what those security measures need to look like. So at a simple level, we're looking at things like limiting access to data sets and documents. So you want to limit access to certain roles within the organisation, and that's only those individuals that do really need to have access to certain documents and data sets. And it's also looking at making sure you password protect documents, and also encouraging the use of strong passwords as opposed to weak passwords. So all things that are fairly sort of, they're not particularly complicated, they're just things that you need to be thinking about. We also then need to be looking at what training you're providing to your employees. So you really need to be raising awareness of the risks that are out there. Now, unfortunately, at the moment, due to the COVID circumstances, a lot of people are taking advantage of the crisis situation that we're in. So we've seen a huge increase in cybersecurity attacks. And for this reason, it's really important that you make your employees and people working for your organisation aware of the increase, and also making them aware of what potential cybersecurity attacks look like. And this is because if your workforce are alert and aware of these, they're far more likely to be reactive, to spot them before they sort of click on a link that's damaging. And that means, as a result, your business is far less vulnerable to these attacks, and it means that you're protecting the data you hold from getting into the wrong hands. On the same topic of cybersecurity, it's also important to choose and prioritise a good software or a good platform that offers a solution which can mitigate those cybersecurity threats. And it's not about investing in a really expensive infrastructure here. It's just about looking at what's available in the market and choosing a reputable brand, because doing so, again, helps to make sure that the data you hold is secure and it's less vulnerable from these external attacks. Now, something else that we would expect to see within an early stage business is that the workforce, so those working for you, are using their own devices, so their own laptops and own mobile phones. And it's especially important that you look at how we keep data secure when employees are using their own devices. Now, in the first instance, you can require a certain level of antivirus software to be rolled out across these devices. So that gives you the assurance that you've got that in place on those devices. But it's also important to look at solutions such as applications which enable you to ring fence or sandbox business data from the employee's own personal data on their device. And this logical separation helps to achieve that security measure. And a final point there on the employee devices is that it's really important that you set rules and expectations so that your employees and your workforce know what's expected of them when they're using their own devices. And a good way of doing this is to implement a own devices policy document. And I think if you're setting these rules and expectations now at the outset, it's really essential, because it means as the business grows, you're going to see more and more employees coming on board. And if you've got these established standards in place, you're going to really achieve consistency across your workforce, and you're going to be comfortable that everybody is handling business data in the way that you want them to. Now, the final element I want to look at on the security topic looks at your third-party processes. So far I've addressed some of the security measures you can put in place internally within your organisation. But I think the bit that people don't always think about is that you also need to be scrutinising the security measures that your third-party processes have in place. And these are processes such as your hosting provider. And the reason for this is when you transfer personal data to a third party who's providing a service to you, you remain responsible for that personal data. And so you need to make sure that you're happy with the security measures that those third parties have in place. Now, you're going to have a contract in place with these parties, which is going to give you a certain level of contractual protection. But you also need to go that step further and just do a bit of due diligence into those third parties. So ask them questions about what security measures they have in place. Have a look at their security policies, which for a lot of big names, you'll be able to find these online. You also want to be asking questions about where they're holding and storing personal data. And this is because if any of those locations are outside of the EEA or the UK, you'll need to be thinking about what transfer mechanisms are in place to safeguard that international transfer. So just a few things to be thinking about. And once you've then collated that information about your third-party processes, you want to be using it as a factor in your decision-making about which third parties to appoint. Because if you're comfortable that your supply chain and your vendors have secure practices, good measures in place, then that's going to reap your reputation, reap benefits for your reputation. Whereas if you're appointing third parties and they potentially don't have those security measures in place that they should, there's a risk that the data you're transferring to them could get into the wrong hands, and this will be reputationally damaging for you at an early stage of the business. Next slide, please, Chris. So the second point I want to focus on is how we achieve the GDPR principle of transparency. Now, there are various principles under the GDPR, and transparency is only one of these. To give a little summary of a few of the others, you've got accuracy, which speaks for itself, for you to make sure that the data you're holding is up to date and accurate. Both data and storage limitation, so making sure you're not holding any personal data that you don't need to be holding, or holding it for longer than you need to be holding it. And also accountability, which is going to be the third point that I address after we've spoken about transparency. So the reason that I really want to focus on transparency is, again, because I feel that this is key for consumer confidence and to really tell people what you're doing with their personal data. And the priority document here is going to be your customer-facing privacy policy. And this is going to be something that's viewed via your website, your application, and the point at which it needs to be available is the point at which you're collecting an individual's personal data. So when a user signs up for your application, can they access your privacy policy at that point? And what you'll typically find in a privacy policy and the things it does need to contain are information about what data you're collecting, what you're doing with that data, why, what lawful basis you have for doing that, and any third parties you might be sharing it with. And what you need to do is make sure you communicate this in a way that's concise and easy to understand. And it really is an opportunity to be creative. So you can produce a document that's consistent with your brand and can really look at who are your audience. If you're dealing with professionals, it's going to be slightly different language you want to use compared to dealing with consumers. And again, if you've got children as part of the data subject base that you're targeting, you really need to make sure that any privacy notice information you communicate is done so in very plain English, so very child-friendly language. And some companies have even considered using sort of illustrations and pictures to really make it a visual exercise. I focus very much on the customer side of privacy notices here, because I think this is what is really key for that building of consumer confidence and customer confidence in your brand. But it's important to remember as well that you're also going to need privacy notices for any other categories of data subjects, whose personal data you process. And a key one that we see for early stage businesses as the workforce is growing and as you onboard employees is your employee facing privacy notice. So that's just another one to bear in mind. Next slide, please, Chris. So the final point that I want to address that I see as being a key priority for early stage businesses is the accountability principle. Now, what this comes down to is the internal records that you're keeping. And the accountability principle requires you to take responsibility for the data that you're processing and to be able to demonstrate that you're compliant with the law. And the way you do this is to ensure that you've got internal records in place. So the two key internal records I want to focus on are the record of processing activity, and this is commonly referred to as the Article 30 record, and that's just because it's Article 30 of the GDPR that mandates you have this record in place, and the other one being your data breach log. So I'm going to talk about each of these in turn. The other helpful tip with both of these is that the ICO has a free downloadable template of each document, so it's not something that you need to spend money on. You go on the ICO website, download it, and there's really helpful guidance on there. So it's something that you can really take away and work on internally. So if we look at the record of processing activities to start with, this is effectively a data mapping exercise. So what you want to be doing is documenting each of your specific processing activities at a really granular level, so setting them out one by one. And for each of those, you then want to document your categories of data and categories of data subject, your lawful basis for that particular processing activity, and any third parties you're engaging in connection with that particular processing activity. I think once you've got this document in place, you've then got really good oversight of where your data is going, who you're sharing it with, and what data flows you have as a business. And the ICO document is a spreadsheet, and that's how we often see people conducting this exercise. So you've got your spreadsheet styles, and it's a really granular exercise for working through. We then look at the data breach log. So this is somewhere where you're going to record not just actual data breaches, but suspected data breaches as well. And you want to provide as much information as possible. So what date did it happen, who's reported it to you? And as well as these key factual details, you want to be assessing whether or not you need to report that breach, and then documenting your rationale for either reporting or not reporting, and also your mitigating action. So with a data breach, you only need to report it to the ICO if it's a risk to the rights and freedoms of the individual involved, or in the case of reporting to the data subject, it's a slightly higher threshold, and you're looking at whether it's a high risk to the rights and freedoms of the individual. So if we use the example of you missending an email to the wrong recipient, it might contain some personal data, but it might be very low risk business personal data. You might decide that that isn't a risk to the rights and freedoms of that individual, and you're therefore not going to report it to the ICO nor to the individual themselves. But what you still need to do is be reporting that data breach on your breach log and setting out why you come to the conclusion that it's not reportable. You also want to list your mitigating action. So here it would be asking the incorrect recipient to delete that email address and confirm deletion to you. And I think that it's important you keep a really sort of granular record there of all the information and the thought process you've gone through, just in case, hopefully it won't happen, but if there is a complaint from the data subject or the ICO investigate in the future, you've got a clear record of what action you took and why. Now, for me, the really important reason to keep these records, so both the record of processing activity and the data breach log, in place right at the outset, is because these documents are going to be easier to put together at the outset. So you're going to have less data flows. Hopefully you won't have had any data breaches yet, so you've got the data breach log in place, ready for when something does happen. And these can then become working documents, and as your business grows, you can add to them. And secondly, with early stage businesses, you're going to be hopefully looking for prospective investment and also prospective purchases of the business down the line. And inevitably, any prospective investors or purchasers are going to want to conduct due diligence into your company. So they're going to be looking to see that comprehensive records have been in place from the outset. And this enables you to show to those investors and purchasers that you have complied with data protection legislation when they ask those tricky questions. So definitely important to get into good habits. Next slide, please, Chris. So in summary, the key data protection takeaway points for you are to prioritise your security. So look at your rules and standards within the organisation, and also look at the infrastructure you're putting in place, and do some research into really reputable cybersecurity software. Then looking at transparency. So here we're prioritising the customer privacy policy. And this is because if individuals understand what you're doing with their personal data, they're going to feel much more comfortable about engaging with you and sharing their personal data with you. And then finally, the accountability principle, making sure that you've got a data breach log and a processing record in place from the outset. And this is going to enable you to demonstrate compliance further down the line. Thank you. I'm going to hand over to Susie now for her e-.
Hi everyone. So the last section of our sort of session today, like I said, is around e-commerce. So next slide, please, Chris. As I mentioned at the beginning, there is a whole raft of legislation which gives statutory protection to consumers, which is why I've chosen to focus on this today. And that includes anyone selling goods, services online, digital downloads. So it really does cover anything as long as you're dealing with consumers. I have chosen, of course, we've only got a short period of time, I've chosen to focus on a few of the key areas that I think it's useful to be aware of. So the first is around provision of information. And I think with all of the legislation, there is a central theme, which is that you need to have transparency with your consumers. You need to have clear, concise terms, which again are in plain English. There's a real focus generally on legislation at the moment in ensuring that consumers actually understand the terms and conditions, and that you're not hiding yourselves from purchasers. So the timing of the information is also something that's a focus in legislation. So making sure that certainly all information is provided to consumers before they actually choose to select the goods or services or the digital downloads that they're choosing to purchase. And in respect of certain key rights, there is an additional obligation that these are really flagged very clearly to the consumer. And this is where you might see online that you get pop-up boxes giving sort of key information at certain stages of that sales process. And that's really to satisfy that requirement. It's not enough anymore to have a link to your terms and conditions with a tick box to say that they've read them. You really do need to go a step further to say, what's the key bits of information? And at what stage do I need to make the consumer aware of that prior to them purchasing anything? So in terms of the actual information itself, there's the obvious things that we would expect we would have to detail to consumers before they've purchased. So, details of what they're actually purchasing, the characteristics of the goods or the services, the price that they're paying for it, but also information around things like delivery arrangements. And that would include not only the delivery charge, but when they would expect to be able to receive their delivery. And there's also information about yourself as a business that you are mandated to provide to the consumer. So there is, quite a lot of detail around exactly what information you should be providing within these pieces of legislation. And perhaps one of the most important rights to make consumers aware of is their right to cancel. And we'll talk about this next, but if you fail to make consumers aware of their right to cancel, then they actually have up to a year to cancel their contract and receive a full refund. So we do actually see legislation specifically calling out a consequence of you failing to make them aware of this quite important right. So in terms of what that right is, if you are selling to consumers at a distance, which primarily today is usually over the internet, but it could be, telephone sales as well, then they do have a 14-day right to cancel or a 14-day calling off period, which is what you might have heard it referred to. And this 14-day right really does apply to most things. There's only some limited exceptions. And those exceptions would include perishable items, for example. In terms of subscription services, there is an opportunity for you to charge the consumer for any subscription services that they get the benefit of within that 14-day period. But again, coming back to provision of information, you do need to make them aware that you intend to do that and what that charge would look like. So perhaps prorated on a daily basis, for example. So again, they don't lose their right to cancel, but you do have a right to charge them just for the period of time that they've had the benefit of those services. So if it's a 30-day subscription, you wouldn't be able to charge the full first 30 days. It would have to be prorated for the period of time up until they've cancelled. There are then some very other limited exceptions that I won't go into, but as individuals on a day-to-day basis, things like theatre tickets and spa days. So when you're looking at those things online and wondering why perhaps there isn't a right to cancel, it is because there are some other limited exceptions. So then flowing from that cancellation right, what do you have to refund to them? And the reason I have flagged this today is because there is a common perhaps misconception that you don't need to refund delivery charges. And that's not correct. You do need to refund the original delivery charge as well as the full cost of the goods and services. However, you can charge the consumer for returning any items to you that they are cancelling their purchase in respect of. And then The last 2 points are really just to make you aware of some broader pieces of legislation, but quite important pieces of legislation. So in terms of the fact that the terms must be fair, there is the Unfair Contract Terms Act, for those that are interested in the legislation. And the general principle of this is exactly that the terms have to be fair and reasonable for the consumer, otherwise they will be unenforceable. And there's lots of things over the years that the courts have determined would be unfair. So a unilateral right to change the terms, lots of unfair practices when it comes to cancellation or return of goods. Lots of those are deemed unfair. Exclusions of liability. Quite often if a supplier or a business is trying to disclaim all liability in respect of something, they will say, actually, that's not fair to a purchaser who should have certain rights if there is a defective product, for example, or a defective service. So generally, it's worth bearing that in mind when you're thinking about the commercial terms that you're offering to consumers. And the last one is really just to flag that if you are selling goods, there are again additional statutory legislation dealing with that, which I don't plan on going into today, but obviously useful to be aware of. Next slide, please, Chris. Okay, so the second part of the e-commerce section that I really wanted to focus on was the new platform to business regulations. And these have come out of a piece of European legislation, but they are enacted in the UK. So there is a UK regulation around this now. And this was really brought in to protect smaller businesses who had their main distribution channel, their main route to market being through intermediary platforms or intermediary services, and wanting to give those smaller businesses fairness in the way that they were being presented to consumers, or at least transparency. And it was also brought in to ensure that some of the larger intermediaries, so for example, Amazon, weren't favouring their own products over other businesses who were marketing through them as an intermediary, or again, at least ensuring a level of transparency around how they were favouring their own products. So, who do the regulations apply to? They apply to providers of online search engines, which is a fairly common and well-known concept to most people, and also to online intermediation services, which perhaps isn't as well known a concept for us. So, what is an online intermediation service? Well, effectively, it's a business or a service that is bringing together or sort of facilitating transactions between traders and consumers. Obviously, the regulations themselves do go into a lot more detail around who would fall into this category, but for the purposes of today, that's really, in summary, who the regulation is trying to apply to. It does expressly confirm in the regulation that it would apply to e-commerce marketplaces, price comparison tools, app stores, and social media. So all of those are definitely within scope of the regulations, but it doesn't apply to peer-to-peer online intermediation services. So it's really looking at that business-to-consumer relationship. If you are caught by the regulation, how does it impact you? Well, the regulation is trying to govern the relationship between the platform provider or the provider of the intermediation services and that business user trying to use that service to market itself to consumers. And the regulation has a number of provisions, detailing what the terms and conditions between those two parties should look like. So, for example, there are again a lot of information around how those terms should be presented, the fact that they need to be in plain and intelligible language. Again, that tends to feature in most legislation these days. And then in terms of the actual content of the terms themselves, it does actually imply some fairly key terms into that relationship between the platform provider and the business user. So, for example, it does mandate that the platform provider has to give those businesses at least 15 days notice of any changes being made to the terms, and a right for the traders to terminate the contract if they're not happy with those proposed changes. So again, previously we were seeing a lot of terms that allowed platform providers to unilaterally change those terms and just give a notification of the change. So it's really trying to address that imbalance potentially between some of the larger platform providers and some of the smaller businesses, although it does apply to the smaller platform providers as well. And then it looks to give information or provide transparency between the parties in respect of things like rankings. So platform providers are required to give a lot of information around how those businesses are ranked, what criteria they're using to issue those rankings, and in particular, if they are selling their own goods and services along those of businesses, how it treats its own goods and services, how it ranks its own goods and services, how it might prioritise its own goods and services. So rankings is a really important feature of these new regulations. And then what happens if you don't comply? Well, in the European regulation, each member state was given the freedom to determine the manner of how it enforced these regulations. In the UK regulations, it does provide for business users to bring an action for damages against providers if they are in breach of these regulations. And actually, member states do have to communicate the identity of anyone who is not in compliance with the regulations to the European Commission. And the European Commission does actually say that they intend to publish details of these entities in the official journal of the European Union. So there is potentially a brand reputation sort of consequence here from failing to comply with the regulations. So on the whole, in summary, I think it's good to be aware of these regulations. Certainly if you are either a platform provider or a sort of intermediary facilitating businesses selling their goods and services to consumers. But also it's good to be aware of these if you're one of those business users who is using a platform or an intermediation service as a route to market or a distribution channel. Next slide, please, Chris. So that brings us on to the end of our session today. Hopefully that focused on some of the key areas that we think it's good for businesses to at least be aware of. We do have an opportunity for questions now, and I think there is a Q&A function within Zoom if anyone would like to submit a question to myself, Chris or Hannah about anything that we've talked about today. But alternatively, we will provide our contact details. So if anyone would like to follow up with a phone call or an email to clarify anything that we've said or to get a little bit more information on anything that we've talked about today, then please do get in touch with us. So I'm not seeing any questions. So if not, that brings us to the end of our session. So thank you very much for joining us today.